This program has been brought to you by Whole Health Family Medicine, your locally owned direct primary care clinic.
You're watching Durango TV News. I'm Deborah Uroda. Rio Grande National Forest Service Supervisor Dan Dallas has approved a road easement across Forest Service land that will open the way for a development that has been mired in controversy and lawsuits for more than 30 years. And this latest decision is no less controversial. Dallas granted the road easement for the village at Wolf Creek, located in an environmentally sensitive area at the top of Wolf Creek Pass. He based his decision on the same environmental analysis that a district court set aside 2 years ago. Dallas said in a news release that he was required to grant the easement by the Alaska National Interest Lands Conservation Act, a 1980 law that says the federal government must provide adequate access for the reasonable use and enjoyment of private land surrounded by federal land. It's the reasonable use clause that is at the heart of the controversy. Dallas wrote in his decision that an all-season resort with residential and commercial development is a reasonable use of the private inholding, but conservation groups have fought the controversial proposal for years, saying it's an inappropriate use of an environmentally sensitive area that serves as a major wildlife corridor, habitat for the endangered lynx, and feeds the headwaters of the Rio Grande. The road easement granted in this latest decision was one of several alternatives included in a 2014 environmental impact statement that analyzed a land exchange to give developers access to the highway. Dallas approved the land exchange, but it was later set aside by a federal district court order in 2017. That's when Judge Richard Match ruled that the Forest Service failed to consider the impacts that the village of Wolf Creek would have on the environment as required by the National Environmental Protection Act. Conservation groups have called this latest decision to approve the easement as an artful dodge of the 2017 court ruling and a violation of federal law.
So it's already struck out twice in court, and to decide that as a foundational document to go ahead and make a decision on, I mean, it is absurd. It's a waste of their time, our time, everyone's time. I mean, how can that, pretty much everyone could figure out that, doesn't make any sense from a legal point of view, ethical point of view.
The issue began in 1986 when the Rio Grande National Forest approved a land exchange to give Texas businessman Charles Level and Texas billionaire Red McCombs ownership in 420 acres of Forest Service property adjacent to the Wolf Creek ski area. At the time, Level and McCombs' joint partnership had proposed to build fewer than 300 housing units. The latest proposal is significantly larger, and without direct access to the Highway 160 corridor, the two businessmen couldn't build the larger development. Starting in 2001, Level and McCombs proposed several plans to obtain access to the highway, but their efforts were stopped by two successful lawsuits. Then, in 2009, the developers offered a third proposal to exchange nearly 100 acres of their Wolf Creek parcel with nearly 200 acres of Forest Service land adjacent to the highway. Dallas approved the land exchange in 2014. Environmental groups, including the San Juan Citizens Alliance, filed a lawsuit in federal district court, and the court set aside the decision to grant the land use exchange in May 2017. Level and McCombs filed an appeal with the 10th Circuit Court, but it was dismissed on a legal technicality in December 2018 and was sent back to the Forest Service for reconsideration. And that's where this latest controversy begins. Environmental groups argue that Dallas improperly based his rationale on a faulty environmental analysis and therefore should conduct another full assessment as required by the district court. Furthermore, they argue that while federal law requires the Forest Service to provide access to the private inholding, it's not required to provide an easement that will allow a development the size of the village at Wolf Creek. Buick-Rude noted that Level and McCombs already have road access to their land over Forest Service Road 391.
The developers have always had access to this parcel, right? They have over the snow access in the winter, and they have road access during the summer. So they like to portray it that they don't have access. Well, indeed, they have access. They've had access for 31 years. They've just always wanted more. They wanted year-round motorized access, and they want, instead of 200 units as in the old days, they want thousands of units. The Forest Service has capitulated to thinking that they need to do that, and they don't have any right to provide any more access than they already had with initial land exchange. They had that access, they had the number of units, they could have proceeded back then, but the joint venture wants more.
Environmental groups have submitted a Freedom of Information request for all documents related to the latest decision to grant access to the village at Wolf Creek. A decision to file a lawsuit is pending. In the meantime, you can read the decision yourself at fs.usda.gov and search for the village at Wolf Creek. You can also find documents on the issue at sanjuancitizens.org. I'm Deborah Uroda at Durango TV News.